thanking Freshfields for having us, for hosting and supporting Washington Arbitration Week. It has been a fantastic first panel, and we will have a fantastic and thought-provoking and arbitration-provoking panel on damages as well. I would like to emphasize that Caroline in 2019 was named a rising star. So now it's 2024. She now is a consolidated star. Now, and Caroline has acted in many international commercial arbitrations and investor state arbitrations, focusing on energy and natural resources disputes, among others in Latin America, the Middle East, and North Africa and beyond. She's co-author of a guide to the ICSID additional facility arbitration rules, and she's many things. She has supported this venture of Washington Arbitration Week in many ways, and she's always eager to have a conversation, thought-provoking. One of the things that really impressed me in terms of practice is that there's much research about what is going on in the world, and some of the cases that she leads and launches are cases that many others want to replicate. So that is something that I've seen, and of course, states are worried when something comes their way. So with that, I would like to give the floor to Kana, so that you also share with us, the place of CPR. Thank you.
Thank you to Jose Antonio for that nice welcome. And I'd like to just say a brief hello so we can get started with our program shortly. Again, I'm with CPR Institute. That's the International Institute for Conflict Prevention and Resolution. And CPR was started in 1977 by a group of in-house counsel who felt that there had to be a better way to resolve disputes. And today we continue that mission as a nonprofit. On the CPR Institute side, we are a thought leadership think tank comprised of members like our valued team at Freshfields. And so I'd like to thank Caroline, of course, for moderating today's program, Olivier, who's been a long time friend of CPR and started our international programming. And we would like to welcome all of you who may not be yet members of CPR to please talk to me at the cocktail hour. I'd be happy to tell you a little bit more and see about having you join our membership, which is comprised of in-house counsel, law firm members, neutrals, academics, and we would really welcome your collaboration as well. CPR also consists of a dispute resolution services, which is our arbitral provider. What's brilliant about the CPR model is our members on the Institute side are the end users and help us to develop the rules and protocols, which are then put in place on the dispute resolution services side. And so it's a nice partnership that we have with the dispute resolution, and they have also a panel of distinguished neutrals from around the world who help to arbitrate, mediate, and facilitate cases that come to the DRS. So there's a lot to talk about. I'd be happy to talk to you more about that. But we're here today, and again, thank you to Jose Antonio for welcoming us to Washington Arbitration Week. This program is particularly impressive because Caroline is leading a brand new group at CPR, which is our Joint Investment Dispute Subcommittee. It's actually a subcommittee of our Arbitration Committee, together with our Banking and Finance Alliance. And I believe this is your very first program, which you've just hit the ground running so beautifully, so congratulations. And so I wanted to just, again, thank Caroline for her work in leading that group, and again, welcome all of you. So I think we have a great program, and we'll get started now. Thank you, everyone.
Thank you so much to you both for that introduction. This is indeed the inaugural event of CPR's Investment Disputes Subcommittee. We have a very ambitious program in the subcommittee. We hold regular calls where we talk about current issues, new cases or new developments in the world of investment treaty arbitration. And we plan to put out some sort of useful work product for our membership of CPR, such as investment arbitration, toolkits and different things. So if you're interested, please come speak to me or at the end of this session, and we would love to have you join us. A big word of thanks as well to Washington Arbitration Week and to Jose Antonio. It is a pleasure for Freshfields to be collaborating with Washington Arbitration Week in order to put on these programs today, and I hope you will stick around for our cocktail afterwards. So the topic for our panel today is remedies in investment arbitration. And, we want to talk about a lot of things that at least are close to my heart when it comes to discussing damages before tribunals and when it comes to the types of remedies that tribunals actually award. And for that, we have a fantastic panel. Let me do some very brief introductions. To my to the left, to your right, we have Karla Čavić, an executive vice president at Compass Lexecon. Karla acts as an expert in many commercial and many investment treaty arbitrations. I've had the pleasure to work with her in the past before, so thank you for joining us. To her right, we have Chris Poulsen, who's a partner at PwC in Canada. We've just discovered our common nationality a couple minutes ago. And so Chris also acts as an expert and provides evidence in relation to the quantification of damages in investment and in commercial arbitrations. And he is part of a team that prepared a wonderful report on interest that we will be getting to in just a few minutes. To my right, I have Karthik Nagarajan, I hope I pronounced that well, apologies, who is Assistant General Counsel, International Litigation at Kimberly-Clark. His previous experience includes being Senior Counsel at RTI International, which is a leading implementer of US aid and other international development projects. And prior to that, he was an arbitration lawyer at White & Case for over 11 years. And last but not least, we have Mark Cantor. Mark was a partner in the corporate and project finance group at Millbank Tweed, and he currently serves as an independent arbitrator, having sat in over 100 commercial and investment arbitrations. He's an adjunct professor at Georgetown University, and he's a member of the World Bank's Sanction Board. And he's also the editor-in-chief of the online journal that I know many of you are very familiar with, TDM, which is Transnational Dispute Management. So with those introductions, we have a number of topics that we want to discuss today. I want to encourage all of you to feel free to just interject with any questions that come up throughout the discussion. And we will, of course, have a Q&A session at the end if you prefer to hold your questions. But let's start off with the issue of procedure. In international arbitration, we are creatures of habit, and we tend to do things often in pretty much the same way, which means that during final hearings, the usual order of proceedings is you show up, you do your openings, then you have fact witnesses, then you have experts. And on the very last day, when everyone is dreaming of getting out of the hearing room, and the chess clock has run out because people have been chasing, rabbit holes with witnesses. Suddenly, you have to deal with the expert evidence on damages, which is very complex, and typically it's on a Friday afternoon. So I want to start off with that. Is that the way we should be doing things? And I raised that question not only to be provocative, but I recently had an experience in an ICSID case where I was representing the investor and had negotiated the sort of rough outline of the sort of hearing agenda with counsel on the other side, and we'd agreed, the usual witnesses, legal experts, what have you, and damages experts at the end. And the tribunal said, well, thank you very much. But what I would like to do is right after the openings, I want to start with the expert evidence. I want to hear from the damages experts because I want to know what it is that is really driving damages and what the issues are, so that then as I listen to the facts and the legal experts, I understand how the pieces of the puzzle fit together. Now, as counsel for the claimant, I was thrilled to hear this. I don't know how counsel on the other side felt about it, but I thought that was really interesting and definitely worth asking the question. Does that make sense? And maybe, Mark, if I can kick off with you with your views, especially sitting as an arbitrator. How do you think we should expert evidence in order to really help the tribunal come to a decision?
Thank you, Caroline. And before I answer your question, let me also thank the organizers of Washington Arbitration Week, Jose Antonio, CPR, and of course, Freshfields, not only for making available this fine facility, but also for allowing Caroline to be here. So I'm grateful for that. You asked me two questions, Caroline. What would make sense and whether we could lead with damages first. What would make sense is to allow enough time for a full damages presentation. And that means management skills on the part of the arbitrators and management skills on the part of counsel, which candidly are lacking on both scores. So I'm not sure that's a useful answer, but it's the correct answer. We should allow enough time for something that is fundamentally important to the parties. Should we lead with damages? Well, maybe yes, maybe no. The advantage is that it makes clear to the parties how much is really at stake and encourages early settlements. The disadvantage is that respondents can, as may have been the case in your dispute, Caroline, see that as a signal regarding the tribunal's view as to the merits of the dispute, no matter how much the tribunal tries to signal that is not the case. And moreover, it's very hard to do that if you don't have a prior resolution or crystallization of core merits issues, core jurisdictional issues, and principles of damages. Because if you don't have that kind of resolution, you still have ships passing in the night.
Sorry. What about you, Karthik? Both as based on your experience as counsel and as a client, how do you view this issue?
Thank you, Caroline. And thank you to Washington Arbitration Week, Freshfields CPR for having us. I would agree with Mark. It depends on the case and specific situation. Some general thoughts, and before I give you those thoughts, I have to say these are my personal views, not that of my employer. It is obviously not optimal to address damages in a rush setting on the last day of a hearing. I think we all can agree on that. But it can, in some circumstances, lend itself to be heard finally, in other instances, as Caroline mentioned, it is good to have it heard earlier. Regardless, with proper planning, the damages portion of a case should be heard fully and comprehensively. With regard to hearing it towards the norm, the traditional way, towards the end of a case, I think a tribunal in those situations may need to appreciate the facts of the case more fully before hearing it. I think in these situations, it could help claimant because they get the opportunity to proffer very, credible and strong fact witnesses who can explain the negative impact the respondent's actions had on the business before the focus turns towards quantifying the impact of such adverse actions. So this approach probably will continue to be the norm, but on the other hand, it can make sense, as Caroline mentioned, and to Mark's point, that damages can be heard first. And yes, respondent may have some concerns, but from a claimant's perspective, it indicates that the tribunal is not going to ignore or make damages an afterthought to jurisdictional and merits issues. It signals, I think, to both parties that the tribunal is using the hearing time in an efficient manner. And it's up to the parties then to use the time as efficiently and effectively as they want. The tribunal is making clear they want to hear damages first, but then you still have other phases of the case that need to be heard, and the parties can, use the time accordingly. So I think it depends on the situation, but it both could work depending on the facts of the case.
Yeah, time management is a big issue, not least because once you get started with the witness and sort of legal expert evidence and you get questions, you start to get a little bit scared about just getting over the hump of jurisdiction and liability. And so you have to sort of balance the, am I keeping enough time to deal, properly with the issue of damages? But if I do that, am I sacrificing perhaps an opportunity to make my case on jurisdiction and liability, which is very much the predicate to the damages issue? But I'd love to get your perspective on this, because you are, of course, the people that were in the breakout room going, your direct presentation you have to be able to deliver it within 30 or 40 minutes or what have you. What's your perspective of that, if you don't mind grabbing your...
Yes. So it's, yeah. Yes, we are the victims, the ones that run at the end. And now, even when you don't have closings, it's even worse for us in that sense, because we are really the ones on Friday. And I cannot opine on what will be the best order. I really believe that, yes, there should be some time management in which you have enough time to deal with the direct, with the question that the tribunal might have for the experts, to do a hot tubbing if they want. What I encountered in a recent case is it didn't change the whole order, but what they did is I was representing a claimant, and what they did, because they were running out of time, so the tribunal decided to do direct, and then cross. Obviously, respondent was not happy about that, but it was useful for the tribunal because they got to see the two positive cases first and compare them, and then also they asked 5 minutes of questions to each of us. They got like a general understanding, and then yes, counsel get into the cross of each of the experts. That was the way of being sure that they were going to get both presentations in time, and then if they had to sacrifice time, it went to the cross. Again, the party that had time available probably was not happy about that, but for the tribunal, that I think that was useful. My only comment will be, yes, how is possible to allow more time for the damage section, because in general what happened is that you end up running out of time from the tribunal also, and sometimes they save of doing some questions and they do it after because they run out of time also. So it's not only from counsel, but also from the tribunal to allow them to have the time that they will need.
I generally agree with that. It's a bit of an idealistic question, right? Because you're saying, should we have more time for merits or more time for damages, and which should have less? And given the choice, I think I would give it to the merits. And because in a number of cases, you know, as a damages expert, you're going last, and you get that direction the night before your presentation to say, look, we need you to strip this back and just do exactly what you were suggesting would happen if damages experts were to go first, which is put this in the context for the panel, how these two theories connect with each other and connect with damages. And so you sort of become the anchor leg in a sense by comparing and contrasting the two different positions. It's not as good as going first, but it's not bad. It allows you to tie it together.
Yeah, I guess the other advantage of going last is that typically the experts have had the opportunity to sit in the hearing room for the whole week or the 2 weeks and listening to the evidence, and of course the expert evidence sits, you know, on the evidence, the edifice of the facts, and the experts can then, you know, connect the dots for the tribunal and say, well, you heard from this witness that in fact the assumption that underlies, you know, our damages theory is accurate or not. But it's an interesting thing to think about. And I had honestly admit that I had never really thought about switching that order around, and perhaps I will from now on. But I want to move on now and talk about it.
Save you time at the end of the day. How did it work?
It worked out fine. It worked out fine, and we got an award that we were very very happy with in the end. So all is well that ends well, right? But you know, that's a happy story. But I think when you talk to counsel generally, and I think that perhaps the feeling is mutual both on the investor counsel side and the damages counsel side, probably the one point that counsel are typically most disappointed with is the award on damages. And that's just anecdotally speaking to my colleagues here and friends at other firms in preparation for today. And the general sense is, at least as counsel, you spend a huge proportion of your time and also resources on a case arguing damages, you know, the damages reports and the other technical reports that feed into the damages reports are typically very costly, take a long time to prepare. There's a lot of counsel input in, you know, coming up with a case theory that then feeds into the damages theory. And so really a disproportionate amount of the resources that go into an investment arbitration go into the damages analysis. But then you get an award that, and typically the damages section, if you strip away this is what claimant argued and this is what respondent argued, and you go down to the analysis, it's often just a couple pages. And it can seem superficial, which is perhaps inevitable given that it's a negotiated outcome on a panel of several arbitrators. It can sometimes appear, I think, to the parties that there's perhaps a bit of more of a Solomonic a basis to the decision, and also, and I've had this experience in a few cases. Often you end up with no decision on damages at all at the end of this long process where you've spent years discussing damages because the tribunal says, well, we've, you know, come to a decision on jurisdiction and the merits, but, you know, now we don't quite know what to do on damages, and so let's run this again. So my next couple questions are meant to address those, and I'm not saying these are fair criticisms and you can all take issue with them, but that's what you know, I and I think probably many of us hear about when it comes to damages decisions. So let me kick off the discussion with the first question being, is tribunal numeracy an issue? And how can we as parties address that better? Ultimately, these cases are in front of lawyers, often law professors, not necessarily people who are used to running DCF analyses or running models in Excel spreadsheets. And perhaps ultimately it's the fault of the parties, counsel, experts for not providing sufficient support to the tribunal to be able to implement the decisions that they make on damages and come up with a number. But Carla, do you want to kick us off?
So I will start with our role as experts on that, because as you mentioned, it's not only the tribunal, and probably we are the first responsibles on that. And I think that as experts, the most important thing is how we communicate our case to the tribunal, and it is central to be able to identify what are the big difference or the larger difference that we have with the other side expert. Focus on which are those main differences instead of sometimes we get into discussion with the other experts about things that probably I believe are correct or not, but don't have a huge impact on the claim. And to be honest, it's something that probably is interesting for a theoretical economical point to discuss, but it doesn't have an impact on the case at hand. So we should focus on what is relevant for the case, be able to say, okay, these are the main differences, were minor. And the second point is once you identify which are the main difference, is to identify the sources of that difference. What is driving that difference? Is instructions, facts, source of data, or our opinion as professionals, methodology. So and that helps. That's the way the tribunal can then decide between one and the other instead of having like two different things that are impossible to compare. And also I think that other thing of the important from our work is to be able to provide to the tribunal as much assurance of what is our analysis as we can by providing alternative assessments and approaches. So I think that those are the two things that are important as experts. Now, in the tribunal per se can also, and I have been seeing that the tribunals are doing more this, is request more work from the experts when they don't do this. I have tribunal asking to meet with the other expert before the hearing and send a table comparing the differences and see if we can narrow those differences, or after the hearing, getting a joint model in which we identify exactly what are the main differences and the impact, and probably also include other tags or instructions that the tribunal might have. For those things to work, you will need to have a tribunal that is well prepared on the case, that knows the case, that is interested in damages. You also need counsel to let the experts interact with the other expert and with the tribunal without interference. And finally, you will also need experts that are able and willing to do that. I have experience in which I have had a conference with the other expert. We decide to narrow differences, and then the table come back. Now we are not going to consider anything because probably there was pressure from the other counsel. So you need the three parts to help on that. I think that the tribunal can probably be the one driving it and putting pressure on that. But at the start, I think that we as experts need to be better at facilitating and educating the tribunal.
Yeah, my recent experience in my exit hearings is that tribunals tend to ask for joint models with express instructions that counsel not get very involved. And I found generally that to work surprisingly well. Even in cases where experts were quite far apart, it's always possible to just create a dashboard that has the different levels, and then just with an accompanying memo that says, for this variable, these are your options, and these are the paragraphs of the reports. And I think that's probably helpful for tribunals, and I've been trying to push that in cases where the tribunals themselves don't push for it. But Mark, what is your view of all of this?
Let's start with the easy question, which is, is tribunal numeracy a problem? Yes. What a surprise. It's also a problem for counsel. And let me emphasize that, because we spend a lot of time focusing on the expert's role in educating the tribunal, and we often forget the primary education role lies with counsel. And that is true not only for jurisdiction and liability, but also for compensation. And it is too often the case that parties will hand over the persuasive aspects of their damages case to the experts, forgetting that a large portion of a damages case is not something on which the expert witness has expertise. We'll come back to that, I know, a little bit later, but definitely tribunals need help. Too often inside a tribunal, one of the arbitrators will be designated to be point on quantum. That's not good for anybody. It would be good, as Carla just said, for the tribunal to be engaged, to be knowledgeable, and to have sufficient comfort with the damages case that all three members of the tribunal are participating. The real world is a little bit different. And when simply attending a conference where we say this is how you ought to do it, is not going to change that very much. I come back to my point about education.
That's a really good point, and it made me laugh a little bit because I've had a lot of exit hearings lately, so I have a lot of war stories. But I had one tribunal where we had agreed on 3 or so hours of openings, and the tribunal said, actually, we want to hear a lot less. We only want 2 hours, and they said, well, why don't you just cut out your damages presentation, because we'd rather hear from the experts on that. But I don't know whether that was just a reflection of sort of the expectations from counsel on the damages front. I would hope not. But Chris, what is your view on this?
It's getting better, but it's not great yet. Before you took the stage here, Mark and I were talking backstage, and 20 or 30 years ago, the predominant damages methodology was sunk cost and asset-based. And we think that may have been just a lack of familiarity and comfort with the income model. But you can see a trend over time with the damages award being based on some kind of income model, which is good to see, and perhaps a continuing trend reflects improving numeracy. That being said, I saw research somewhere that said that I think it's like 6 or 7% of arbiters have some kind of engineering or financial background, and the rest have none, which makes it pretty clear what the expert and counsel's job is. I mean, you can't have a nuclear physicist on the panel when you need one, but that's what you've got experts for. And I agree, narrowing the list of issues is absolutely fundamental, but all too often I've seen the issues narrowed only for the experts to talk past each other in theoretical Nobel Prize winning formulas. And that's not helpful to anyone. I think any expert worth their salt can reduce a Nobel Prize formula to something understandable and common sense. And that's the piece that's missing. Experts that are comfortable enough with their position that they can articulate it simply without the need to rely on numbers.
No, that is a good point. And you were talking about experts talking past each other. What about hot tubbing? Is that something that any of you think is particularly helpful, to have the two experts in the box getting peppered with the same questions at the same time? Mark, as an arbitrator?
I think hot tubbing is only valuable if the arbitrators are prepared. If they are not prepared, then I think you get a variety of vague, open-ended questions lobbed at the experts, and you don't crystallize any disputes. That means thinking how to get the arbitrators prepared. I know we'll talk about this a little bit later, but Carla and Chris have already mentioned the value of having a checklist of material items of disagreement in advance, because that forces the tribunal to focus on the things that make a difference in the damages case. And that can help the tribunal understand where it should be asking questions in a hot tub. And I strongly endorse the idea of getting a checklist of material disagreements. Candidly, I not only do that for damages, I do that for jurisdiction and merits as well, for exactly the same reason.
No, I was going to say, great point, Mark. On the back end, towards the end of the hearing, I think when the tribunal is thinking of post-hearing briefs, in order to encourage that numeracy point, the parties should offer, or the tribunal should ask on its own, here are the issues that we want to have addressed in the post-hearing brief on damages, or, on other issues too. But I think that will help the parties educate and inform the tribunal on those issues in a more succinct way, because otherwise, you get 50 pages, 100 pages for post-hearing brief. Maybe not. Damages is getting the correct treatment and the correct focus. So the tribunal sends the questions in advance. They get, it encourages better understanding of the issues.
So let's talk a little bit about the delta between damages claimed and damages awarded. I think the statistics show that for claimants in investment disputes that get over the hump of jurisdiction and liability tend to be awarded roughly half or slightly less than half of the damages that are claimed. And I would like to ask you about your thoughts as to what the causes of that discrepancy is. Is it that there's such a huge delta between the positions of claimant and respondent? I mean, I've had cases where I've been claiming billions and the respondent claims that there are negative damages. And so, you couldn't have a wider delta. Is it that tribunals are just not buying the investor's damages claim? Is it that the sort of methodologies that are being used are not ones that tribunals feel comfortable with? What is it? What is the driver of that delta?
Two general points before I get specific. The first general point I'd like to make is one that I just made a few seconds ago, which is the focus on experts is over-exaggeration. Okay, there are lots of players in a damages case that lead to exaggeration, not just or only the experts. Second, in discussions about the delta, too often the conversation is only about the claimant side. No doubt about it, claimants regularly exaggerate. So do respondents. And one thing that drives me crazy about this topic is that we do not spend any time, for example, in UNCITRAL Working Group 3 or UNCTAD reports, talking about when respondents exaggerate their position. And one consequence of that is we get one-sided biased conversations, and that does not help move the ball forward. Now, what causes the differences? Well, the first point is that if we're looking at, for example, DCF valuations, they rely on assumptions about the merits of the dispute, about future cash flows, discount rates, growth rates, interest rates, inflation rates, foreign exchange rates, and other factors. Where does this information come from? Well, it comes from different instructions from the engaging party and counsel. Can't blame the expert for that. Different positions on merits and jurisdiction. Can't blame the expert for that. Different positions on legal issues related to quantum. For example, whether a DCF is speculative or reasonably certain. Well, to some extent, experts play an important role in that question, but so do counsel. Different commercial, regulatory, and political, micro and macroeconomic assumptions. There, quite often, the expert takes information from the party who has engaged them or counsel who's instructing them. Different sources of data. That's most obvious when we're comparing the claimant side and the respondent side, because they get their data from different places, different parties. And finally, we finally get to something we can blame on the experts, the design and complexity of competing models. So when I go through that checklist, which by the way is not mine, you can find it in the GAR Academy of Damages guidebook on damages. You see that the focus on blaming the expert, in my view, is mistaken. And also you begin to understand the next comment I will make in due course about how much of the damages case has little to do with numeracy.
So you're not to blame, Chris and Carla, but
It's a good thing we're sitting down here.
exactly. No, but just briefly, because we're running short on our time, but just briefly, what do you do to help with these, credibility issues?
So I think that as an expert, one is going to present the case that you can defend and feel comfortable with. And it's true that the framework is going to be informed by instructions. So let's start with the measures. What are the measures? What is the date of evaluation? That is something that I'm going to receive as an instruction. Starting from there, as an expert, I only take instructions that make sense, are reasonable, and are beyond my expertise. So I'm not going to get an instruction about what price to use or about what valuation methodology to use. So I think that for a credibility issue will be first that the instructions that we receive are reasonable and are outside of our expertise, and it's good to have it from counsel. The other issue is related, as Mark mentioned, evidence, right? You have to put the case to the tribunal, and to make that case credible, you have to use as much evidence as you can. And it's true that much of that evidence can come from your client, but at the same time, you can validate that evidence with third party and outside sources. So I think that is also important. It's not that I can take blindly what I receive from the client. And as I mentioned before, probably trying different approaches, methodologies or sources or information to give to the tribunal a sense of that the number that we are presenting is consistent with other sources, approaches, and information. And that I think that is how you present a case as a damage expert that is credible to the tribunal. But yes, we have to admit that a lot of the difference that we will have will be defined by the instructions.
And if I can just ask, about the issue of pushback, right? Because as an expert and also as counsel, how you feel about this, I find some of the most effective experts are the ones who say, wait, this assumption, I don't know about it. And these numbers I need to, validate and have, some other source. What do you view as sort of the expert's role, or how do you view it when experts, push back in that way in order to maintain not just the credibility of the damages case, but also their own credibility? Because ultimately in investment arbitration, it's such a small world. There's such a small pool of arbitrators, and then, a limited number of experts who appear on a recurring basis in front of these same tribunals. I imagine that one of your concerns is, to be known to be credible and to not be putting forward, a damages case that is speculative or perhaps not fully supported. But I open that up to anyone who wants to take it.
So a quick reaction yes, the reputation and credibility is the only thing that we have. So it's not only presenting a case that is credible, but also being consistent. So between your cases. And the other thing that you touch on pushback, you have to do it because at the end of the day, you are protecting your reputation, but also you're protecting the case. If I get to the hearing and I am destroyed and crossed because I accepted something that was unreasonable, it's going to be bad for the case. So that is a little bit of education. That especially happens with clients that don't have experience in arbitration. And counsel, it's good to have a counsel that helps on that education, but otherwise, as an expert, you have to do it. And at some point, it's yes, I want to be credible. For me, my reputation is important, but at the end of the day, this is going to harm your case. So that's why I'm telling you that I am not going to go there. But again, it's a education, but probably for the client in that case.
I was going to say, I 100% agree. You have to back your numbers, and it may take some more work on the front end to get the data, check it, test it with your expert. But if you don't have the data, you shouldn't be presenting. Otherwise, I think it's a matter of credibility and, legitimacy.
There are some numbers that are unknowable at a given date. What do you think about the idea of a range being presented where there's no precision possible?
Why don't I take that since
Sure.
I'm the one who'll have to deal with it?
Yeah, I'm curious.
The answer is I do like the idea of sensitivities. Best case, base case, worst case is often an easy way to do that. What it does, though, is it lets the expert off the hook, because then you're saying, okay, here's some possibilities. Arbitrator, now it's your problem. But in the end, it is the arbitrator's problem. If I were a judge, you would want me to exercise judgment. These are not mechanical exercises. And the word judgment plays a very big role in anything where there is a level of uncertainty. So I have no problem at all with sensitivities. I do have a problem, though, if you want to give me so many sensitivities that I'm just going to pull my hair out. I don't have enough hair left for that.
I want to move on to the topic of interest, which is, incidentally, I have a ICSID filing today, and usually by the time I get to the point of the day in the filing where I'm getting to interest, I'm like, oh, it's just interest. This is easy, and I want to challenge that view, because ultimately interest, especially in investment cases where you can have very long arbitration cases and long runways from the time of a measure until a final award, interest can sometimes be half or more of what you're claiming, and are the participants in the process really thinking about it as much as they should? And I say this in the backdrop of, as we know, a lot of investment awards that award relatively low interest, LIBOR +2. I've even seen some recent awards come out with risk-free interest, which in the context of an investment dispute, often effectively means that, the state is getting an award with an interest rate that is significantly lower than its own borrowing rate. And then we can go on to the discussion of enforcement as to why would you hurry up and comply.
Can I check on a book? What I wanted
with,
the book to be, so this I realized I've read, so I don't need this book anymore.
Let's see, maybe we have a new participant in our conversation. And so I raised that question: what is the right way to deal with interest? Should investment tribunals be dealing with the issue in a different way, or should parties and experts be presenting those issues differently? Chris, do you want to kick us off?
I'll say a few comments to start and then turn it over to everyone. It's a big issue, and it doesn't nearly get enough attention. I don't know if you've had a chance to read that research yet, but you were pretty close to dead on. The average award, about 29 or 30% of it is interest. And the average amount of interest awarded over the last couple of years is $175 million in ICSID cases. So it's an issue that deserves consideration. It is fundamentally an opportunity cost consideration. Had the respondents not had the funds, or had the claimants had the funds, what do you need to do to make them whole again? That's something you've got to seriously consider and give some thought to. Based on the research we've done, I think cost of capital only gets awarded in 1 or 2% of the scenarios. Now, that's a pretty high bar to demonstrate that absent this breach, whatever it was, there was some sort of opportunity that only that capital was available to pursue that opportunity. I saw it a few years ago, successfully awarded in a mortgage-backed securities case, where people were raising funds and immediately they'd use it to buy mortgages or more mortgages. And they successfully demonstrated, had we had the additional $200 million, we certainly would have bought more mortgages and gone through the whole securitization process. But generally speaking, it is risk-free or LIBOR plus 2. LIBOR plus 2 makes sense to me as sort of a borrowing rate. You know, we would have either repaid some debt or, you know, absent any other demonstrable opportunity, it's sort of something better than risk-free. But the weighted average cost of capital is a very high bar and certainly doesn't get enough evidence presented to justify it in most cases.
I'll let you all respond, but I want to throw out there the idea of the forced loan theory that has been popping up in quite a few awards, which is interesting. Conceptually, the idea that if the respondent breached the treaty such that it owed compensation from that point onwards, effectively what has happened is that the investor has been forced to effectively loan that compensation that was owed to it to the state, and consequently, an equitable interest rate would be the rate at which the state is the rate at which the state borrows money. Mm-hmm. And that's it. It's popular with some states. It's a lot less popular with other states. I recently had a case where the state had argued forced loan, and then because of political and economic shifts, their loan rate changed significantly over the course of an exit arbitration. But I throw that out there for anyone who wants to catch that ball.
So the course loan theory at least provides appropriate incentives to pay the award. So at least you are there. But I view this a little bit different. At the end, what happened as an investor is that you were forced to keep the money in the asset. You delay collection of the asset because of the measures that you are claiming. And the only way I am keeping money in that asset, or similarly is the same, investing in that asset, is at the cost of capital. So that is my rationale of why a compensation related to the cost of capital makes sense. That being said, it's true that it's not awarded often, especially in treaty cases. Commercial cases, it could be more popular, but not too popular either. But at the end, that cost of capital is the only rate that is going to compensate the investor in this case, or claimant, for that delay in receiving the cash flow of the project that he's delaying due to the measures. The rates below that will fail to do that compensation. And when you go to rates that are close to the risk-free or very benchmark rates that are pretty low, especially when you're dealing in investors such as, I'm Argentinian, so in Argentina or similar, where you will never get any investment or do any investment at rates that are like LIBOR or risk-free for sure, or it ended up having a total lack of not only compensation, but link with the asset. And at the end, this is part of the damages, and the damages arrive from a particular asset in a particular country. So all the other rates, for me, fail to have the relation with the asset and give you take you to a situation that is hypothetic and outside that asset.
Conscious of time, do you have any quick reactions on that, Mark?
The way I organize the question in my mind is first to ask whether there is a binding legal rule. And that can come from three different places. It can come from the arbitration rules, which may instruct me that I have to use a commercial rate. That's going to cabin what I'm going to do. Second, if I'm not caught by arbitration rules, I may be caught by a national law. That's particularly obvious in commercial cases, and it may compel me to use a particular rate. And the third point might be a contract agreement, where the parties themselves have specified what kind of interest rate is to be used in a default scenario. If I don't have a binding legal rule, then I have to ask myself, am I looking at a situation where the object of interest is an incentive to pay and a gross up? Or is it a form of compensation for injury? If it's an incentive to pay and gross up, I've got a lot of flexibility in how I deal with that. And I would guess that a lot of tribunals fall back on something like LIBOR plus 2%, although they have no idea how to calculate LIBOR. If it's compensation, then, Caroline, we're talking about either looking at it as a forced loan, or we are looking at it as a foregone opportunity. It's a forced loan. You look to what the borrowing rate of the other side would be. What would they have had to pay if they didn't have the benefit of this money? And if it's a lost opportunity, then you're looking at the cost of capital, the weighted average cost of capital for the injured party. That's how I organize the question in my mind. Is there an answer to it? Chris, I was looking at your report earlier today, which you kindly shared with me, and I noted with some amusement that 80% or more of relatively recent cases accept compounding of interest now, not just simple interest. That is such a change from both national law and practice in the arbitration world 20 years ago, that is at least as important as the question of what rate is used.
Absolutely. Well, look, I want to, I think we have time for one more topic before we open up the Q&A session. So please do start thinking about your questions. And the last topic I want to touch upon is, let's put damages aside for a minute. Should tribunals be thinking about remedies other than, a fixed amount of damages? And here I'm thinking about restitution, specific performance, injunctive relief, and I wanted to throw out there a recent award that hasn't gotten a whole lot of attention, but there was a recent award in which a tribunal ordered indemnities, an indemnity for future damage. In other words, there were certain measures that had not yet crystallized in a damage, and what the tribunal said is that the state's conduct was in breach of the treaty, and that if it continued to pursue that conduct such that a damage was suffered, then the state should pay an indemnity. And I wondered, I wonder what your thoughts were on that, and what your thoughts were generally about being a little bit more creative about the relief that is sought. And maybe if I can start with you.
Yeah, thank you, Caroline. And I'm cognizant of time here, so I'll try and be quick. First off, congrats on that case. I think she's referring to South 32. So yes, tribunals should be more creative, not creative, but should be more open to awarding remedies like indemnities, restitution, and specific performance. While pecuniary relief will likely be the norm, particularly in instances where the investment relationship is broken down and the claimant is out and just wants monetary damages, it shouldn't stop the tribunal from considering non-pecuniary relief when claimant is seeking it. Restitution, just really quickly, there was a case, Karen versus India. Tribunal ordered respondent there to withdraw the impugned tax assessment orders. The case was later set aside, but corresponding to that set aside, there was a settlement between the investor and the government there that allowed not only payment of the taxes back to the investor, but also legislation was passed at a national level that scrapped the tax orders that the tribunal had ordered restitution on. So I think taking that into account, there's three key takeaways. One, it provides non-pecuniary relief, provides a menu of options for claimants who may be seeking to operate in a country, right? And they may still need something from the government, and the investment relation is still not completely fractured. So specific performance could be helpful. Injunctive relief may be required, particularly if you're trying to protect IP rights. So it can be helpful. Two, the award, in a final award, if a tribunal has pecuniary monetary relief and non-pecuniary relief, and the parties are then trying to reach a post-award settlement of some sort, it gives more room for give and take to both sides, really. And then finally, to the indemnity point that Caroline mentioned, there's it's a pretty, I think, new development or novel, I think. But I think, looking at it from both sides, it contains respondent from not engaging in future conduct that has already been established as a violation of international law. And it provides the claimant some legal certainty that maybe they can continue operating, which ultimately benefits the host state, which is the whole purpose of, the system we're discussing. So I'll stop there with those thoughts.
You have to divide the world between investor state and commercial. In the case of investor state, it is clear from recent treaties and what's going on at Working Group 3 that there is no realistic prospect of arbitrators being granted more remedial power rather than less. The pushback on specific performance, the pushback on permanent provisional measures, permanent measures, injunctive relief is incredibly strong. You're not going to see that change. With respect to restitution, well, the situation in existing treaties, it requires state consent. By the way, my computer has just died. My apologies. Yeah. And state consent will depend on whether they see restitution better than monetary compensation. And the last point to make is, at least if we are looking at the ICSID convention, the only award that is entitled to be treated as the equivalent of a final court judgment is the pecuniary aspect of the award. So I think it's a real uphill question in the community to get anything beyond pecuniary measures. I think it's different, though, if you are talking about interim provisional measures, because there does not seem to be the same sort of pushback. And one painful peculiarity of the investor state world is those cases take years. So interim injunctive relief in those cases can actually be a meaningful remedy.
Yeah, no, that's interesting. And I'm reminded of, I think it's Canada's treaty practice to put in its investment treaties that the tribunals can award relief other than damages, so long as they give the state the option to pay damages in lieu of restitution.
Yes, you find that starting with NAFTA. It's the same in the American treaties and in the treaties that parallel the American model that began with NAFTA. But once again, it's state controlled.
But do you think, I guess one question is just, wouldn't states prefer to have the option, right? If you are suddenly told that past conduct or continuing conduct is in fact in breach of your international obligations would a state act. And I understand the whole discussion at Ancestral Working Group 3 and the pushback against this, but I wonder whether in reality, that optionality wouldn't be something that's welcomed by states. And I think with that, we can continue the discussion, but I want to open up the floor for questions. Do we have any questions in the room? Don't be shy. What I would suggest we do is we just take a whole bunch of questions and then let the panelists answer in a rapid fire way. Any burning questions? If not, yes, we do have one.
So there be a concerted effort to introduce more guidance or standardized methodology calculating damages, including consistency and fairness?
So I will. I'm not sure everyone understood that. Maybe for people online, I think the question was, given the complexity of the issue, should there be more guidance on the way damages are presented on methodologies? Any other questions? Yes, Marin.
Just thought, you alluded in a couple of comments to the phenomenon of ships passing in the night with the expert reports, which is often a function of things like valuation dates and the like that the tribunal needs to decide. Should we be thinking more often about bifurcation of damages entirely and putting this all to one side until the tribunal has made all its merits decisions? It seems like many awards are kind of heading in that direction after the fact, right? You're getting more and more awards that are partial awards and say, now we'll go back and deal with damages again. Maybe we should be, in the interest of efficiency, just setting the whole thing aside until we get to the end.
Well said. Any other questions? While I'm up with the mic here, I'm like Oprah.
Thank you.
So I agree that probably injunctive relief or what's the other one? Is not probably a good thing for arbitral tribunals to enforce. But for those that argue for injunctive relief and other types of just non-monetary awards, how would that work? How would the arbiter or the tribunal oversee that and ensure enforcement?
All right, unless there's any other questions, maybe you can rapid fire. Oh, we have one more over here. Oh, questions online. Let me see.
There's two.
Oh, that's what you were trying to tell me. I'm so sorry.
No, it's
okay. I will introduce these questions. One is, can written submissions and arguments be submitted at the end of the hearing so that if damages are not allocated, the party can go back for appeal on this point of damages? And the other question is there any standard protocol to be followed by arbitrators? And I believe those are the questions. Of course, and I'll kick off by saying that in investment arbitration, there is no appeal. And so the only issue typically is annulment, which is focused less on the correctness of the damages award, but more on process issues. But maybe you can each pick a question that you want to answer with. We'll start with Mark and we'll go down the table and then we'll get some wine.
I will try to be quick, but the question that was asked about steps you can take is one that's near and dear to my heart. When I'm allowed to control how a tribunal deals with this issue, which happens far too rarely in my circumstances, I would like to deal with jurisdiction, merits, and principles of damages in an initial phase. And I'll come back to what I mean by principles in a minute. And then having sorted those things out, instruct the experts to come back with revised numbers, a joint model with toggles if possible, on paper, not new evidence, the existing record. They present their numbers, counsel can comment on that, and then we resolve that second phase as a documents only process. So it doesn't take anywhere near as long as a second evidentiary process. What do I mean by principles of damages? As I hinted earlier, there are a large number of topics that can be resolved early on in a damages case without having to get into the 2 + 2 = 4 question. I could list 25 of them, but Caroline doesn't have enough patience for that. So let me quickly identify a few of them. First, the core principle of compensation. Is it to put the injured party in the position they would have been in if the unlawful conduct had never occurred and the transaction had proceeded as expected? Or is it to put the injured party back in the position they would have been in if the transaction had never occurred? That's the cost method. And in either case, are there adjustments necessary up or down for unjust enrichment of either the claimant or respondent? That can be dealt with as part of the first phase. So can whether a DCF valuation in the circumstances is speculative or reasonably certain. In effect, is the model reliable? Third, causation. That can be dealt with up front. Foreseeability of damages. Whether the country risk is dealt with in cash flows or in discount rate. You can answer that question up front. What is the applicable inflation rate? That's not a hard question to answer up front. What about the applicable growth rate, both within the forecast time period and for use in a terminal value if a terminal value is appropriate? Again, you can decide that up front. Principles of pre-award and post-award interest, which we've talked about. Choice of the applicable currency for ultimate compensation, for interest rates, and for foreign exchange rates, and the valuation date. There are other items I could mention, but all of that, if you decide that as part of a first phase and ask the experts, now go back and rerun your numbers based on that and our merits conclusions, you will get an enormous reduction in the disparity between the two parties. Will you reduce it to zero? Never. There are always going to be differences, but it becomes a manageable problem.
Thank you. I will take the question on injunctive relief. You know, if you don't have the ability to enforce it, what value does it have potentially? I think there's 3 points. One, a company or an investor may seek injunctive relief, to signal to its shareholders and others that it is taking all steps to protect the company and is following the most prudent approach. And hopefully the respondent complies, but let's say they don't. You still can use that order potentially in other proceedings if there are other proceedings underway in other jurisdictions as evidence. You can use it as part of a media strategy. It is better to have it than not. 2, in the proceeding itself, if the one party fails to obey the tribunal's order, the other side can use it, the non-compliance, as part of seeking costs. And 3, I think when the tribunal orders injunctive relief, obviously it's to that issue, but it can signal the tribunal's thinking to larger issues, which may encourage early settlement. So I think it has utility, even if there's a possibility that the party may not necessarily comply.
Chris and Carla, any closing thoughts or answers?
I'll bet you I have the same answer as Carla on whether more prescriptive damages methodologies would be. Yeah, no. I think that sort of limitation could become unhelpful in scenarios that weren't contemplated when the rules were put in place. Simply, the issue of bifurcation is an interesting one. A lot of people have spoken about it and pressed for it, but one benefit I see of having them both unfold at the same point in time is a sense of the materiality of some of the different assumptions or instructions given from counsel. So how big of an issue is valuation date? How big of an issue is, one assumption versus the other? And it allows the panel, I think, to listen with special interest to those issues.
Yes, going to complement to that, there are some times that the impact of a measure that is discussed is not so straightforward. So at that point, it's useful to have the economic expert interacting at the beginning of the case. And that makes explain why you don't have bifurcation. Sometimes I would like to have it, so when I get to the hearing, we are not talking about two different dates of valuation, for example. But there are other times in which what is the impact per se of the measure has an economic component, what is that consequence, how it affects the investment, if there is mitigation. There are parts in which the economic analysis can play a part on the legal case. So that might explain why there is no more bifurcation, but that's probably for the lawyers to discuss. And regarding standardization, I agree. The standardizations that we have most of the times are, I would say, outdated maybe, like we were talking about no DCF or using simple interest. That doesn't mean that the arbitrators and the lawyers shouldn't have that checklist and the points that Mark were raising, because those are the important ones. What for me is difficult as an expert is someone else telling me if I have to apply compound or simple interest. That is something that I have to opine on. And actually, there is no discussion on that, but that kind of thing. So that's my difference with having standardization then.
Well, thank you very much. 3 final points before we move on to the wine and eats. First point, Freshfields is happy to be providing New York and California CLE credits for this panel. So to complete the process, you have to scan the QR codes on the registration table outside and complete the form. And I will now announce the winning lottery number, the CLE credit number, which is 2688. So once again, the CLE number that you'll need to fill in on the form is 2688. Second point is a final plug for CPR's investment disputes subcommittee. I very much hope you'll consider joining us, and please come talk to me over wine, and I can tell you how you can join. And finally, just a word of thanks to our panelists. Thank you so much for making this a really interesting discussion, which we can now continue over drinks. So thank you.